One of the last things that you need to think about is whether or not to incorporate. So this is a different legal structure for a club that is currently unincorporated as an association. So you're more like a members association with a rule book, and you may want to become a company registered at Companies House so that you have the benefit of limited liability. Now you can incorporate as a company limited by guarantee or a company limited by shares with equal shareholding for each member. If you remain unincorporated, it means that you don't have a separate legal personality. So when you enter into contracts, that's in the name of the committee members. Whereas if you incorporate, you enter into contracts in the name of the company. So although you don't have specific administrative requirements and you have less governance requirements as an unincorporated association, you are taking on a lot more of the risk as individuals. So remaining unincorporated is generally okay for smaller clubs which don't own any assets, you don't take on any contracts, you're not involved in any high risk sports, and you're fully protected through third party insurance. However, you should consider incorporation if you are taking on contracts, if you're employing staff, if you're taking on finance and loans, if you're entering into a lease or buying buildings. We would definitely recommend considering incorporation. Another really important point to note is that if you do incorporate, it means that the committee members become directors of a company, and this means that they're fixed with the statutory director's duties, of which there are 7. That means that you must act within the powers of the company, you must promote the success of the company at all times, you must exercise reasonable care, skill and diligence and independent judgment, you must avoid conflicts of interest where you can, you must not accept benefits from third parties, and you must declare an interest in any proposed arrangement or transaction with the company.